Hi, I'm David Tarras, partner at the Rossen Law Firm and head of our federal criminal defense practice and our white-collar criminal defense practice. I'm here today to explain to you and talk to you about one of the most frequently prosecuted crimes in federal court, or in white-collar court in general, and that is wire fraud. Wire fraud falls under a larger category of fraud, theft, embezzlement. The reason why we're specifically talking about wire fraud today is because according to the most recent reports, there are hundreds of different kinds of federal crimes. And nearly 11% of all federal crimes that are prosecuted in the United States District Courts are related to fraud, theft, and embezzlement. And wire fraud is the big one. If you are facing an investigation by a law enforcement agency, whether it's the FBI, Department of Defense, IRS Criminal Investigation Division, some agency that is looking to either speak to you, to prosecute you, to indict you, this can be one of the most scary and harrowing experiences of your life. You need an experienced federal criminal defense attorney who knows wire fraud, who knows the intricacies, the elements of the crime, the defenses, and the penalties, so that you can be in the best position for not only yourself, but for your family as well, and we can hold your hand through that entire process and get you the best result possible. So, what is wire fraud? The federal wire fraud statute is 18 U.S.C. section 1343. To convict on wire fraud charges, the government must prove that a person intentionally used some kind of electronic communication, such as a phone or email, for purposes of committing fraud. Now, there are specific definitions that we're going to talk about, as well as the legal elements. So, the legal elements of wire fraud. First, we have a scheme or artifice to defraud. This element requires the prosecution to prove that there was a scheme or plan to cheat somebody of money or something else that has value. Second, the scheme involved false representations that were material. The prosecution has to prove the false statements were made, okay? But these false statements have to be material, and that's a very important aspect, and we're going to speak about that. I would say most importantly of the elements that we have here is an actual intent to defraud. It's something that attorneys miss very often because of how overcharged this statute is. They think that once you have wire fraud, because it's such a catch-all, their client might already be in so much trouble that the cards are stacked against him with the way federal prosecutions work. That is not the case, okay? The prosecutors have to prove what we call the mens rea, the criminal intent. They have to prove that in making these communications that you had the intent to deceive or defraud. Now, we're going to have other videos on who these frauds might be directed towards. It could be directed towards a medical institution, it could be directed towards a federal government program, financial institution, and the ways that those cases play out, depending on the institutions, have intricacies in and of themselves that we're going to talk about. Wire fraud is extremely overcharged. There has been lots of litigation, there have been legal memos, there have been large criminal defense organizations who for years have been fighting against how broad this statute actually is. We fight against it, I fight against it, because it is so commonly charged and it's such a catch-all. That creates a lot of problems if you have an attorney who is not specifically trained and has an expertise in the intricacies of this statute. But from a very general standpoint, the prosecutors have to prove intent to defraud. It's not enough that you just have a communication that went from one person to another and the prosecutors say, well, it was involved in a fraud and we think it's fraud. No, there has to be criminal intent. That gets lost in the filings. It gets lost in the indictments. It gets lost in the fear that people experience when they're facing this kind of prosecution, because wire fraud carries with it some very, very harsh penalties. And one of the reasons that attorneys like us, experts in the federal criminal defense community, really hate this charge is because it is so commonly indicted, because the prosecutors feel it's easy to prove. The way the statute reads is they don't, on its face, don't really have to prove much. For example, a cell phone communication from one person to another. They don't have to prove that that cell phone communication was fraudulent in and of itself. They just have to prove that a totally valid communication, John Doe texting Jane Smith, about something related to what the government believes is a fraud is a wire fraud, according to the government. And it's overwhelming. You'll read if you get indicted, God forbid, and you'll say, really? This is wire fraud? And really, this is something that is punishable by up to 20 years in prison? But wire fraud of potentially all charges you could ever face or be investigated for is the most broad, it is the most hard, most difficult for a layperson, for our clients to process without an attorney such as ourselves to walk them through the process. Because when you read this statute, you think, well, what is not wire fraud? If the government thinks I'm involved in any sort of fraudulent activity, any sort of scheme, and I make any communication, if I text somebody across state borders, if I send an email and they think that that email, even if completely harmless, is related to some larger fraudulent activity, next thing you know, you're getting a knock on your door by the FBI, you're getting a knock on your door by the Department of Defense, whatever agency it might be, and you're saying, guess what? You're lined up for an indictment. Great thing about us is we love to come on early at our firm. It is crucial. As soon as you're first contacted by law enforcement, especially in wire fraud, because it is so broad, you need attorneys like us who can break down the specific elements of it. Look at the discovery. See what really was intentional here, if at all. Did you know about the scheme that was going on when you made these communications? The penalties can be very, very severe. Wire fraud charges carry up to 20 years in prison, as we just mentioned. Now that's on the sentencing code. We have another video that you'll be able to watch that talks about how federal sentencing guidelines, federal sentencing works in general. You have the sentencing code, which does max penalties and any minimum penalties. But the big thing that you're always dealing with a wire fraud or any sort of fraud, theft, embezzlement related federal white-collar crime has to do with the loss table. The loss table is under the United States Sentencing Guideline, Section 2B1.1. So we've discussed wire fraud generally, okay, and why it is so important for you to hire an experienced federal criminal defense attorney in white-collar crime, specifically as it relates to wire fraud. Now this is interesting, but it's also scary. In a very high-profile case in the United States District Courts, not too long ago, a prosecutor in that case referred to wire fraud as the Louisville Slugger, or the Colt 45 of the federal prosecutor's toolbox. Okay, that is how prosecutors to this day feel about wire fraud. It's their sledgehammer. It's their, I can get anybody with this because it is so broad, and once we bring it, once we indict it, they are locked in. We do not feel that way. We are going to continuously fight for all of our clients, so the prosecutors cannot bring this Colt 45, this Louisville Slugger of a charge and an indictment against our clients. We're going to push back. We're going to bring the Colt 45. We're going to bring the Louisville Slugger to them. We're not going to roll over just because for 50 years this charge, this statute has been railroading people. We're not going to let it happen to you. If you hire us, I guarantee you that you will have the absolute most elite and zealous representation on all of your federal and white-collar concerns.